Good morning, everybody, and thank you for attending our seminar today on the five fair reasons for dismissal. My name is Michelle Kemp. I'm head of the employment team here at Frettons. I'm joined today by Chris Dobb, also a solicitor, and Kate Fretton, who is also an employment solicitor here. And we are also joined by Nathan Andrews, our head of HR services. Firstly, I'm sorry we're not at the Tooting Glen today. Unfortunately, their refurbishment works meant that we can't be there, but never mind. Right, so today, as I've said, we're looking at the fair reasons for dismissal. This is obviously important now, especially when we're dismissing an employee with unfair dismissal rights. But with these proposals for day one unfair dismissal rights coming, we will all need to focus our minds in relation to which reason we are relying on to dismiss an employee in more situations than perhaps we do now. So today we're going to have a look at the legal issues that might arise in relation to each reason for dismissal and what a tribunal will look at when they're determining the fairness or otherwise of a dismissal. We'll also have a look at some of the more quirky issues that can arise when dismissing and how we can tackle those issues as well. We won't be covering procedure in detail today because obviously what we're looking at is a huge topic. If we add in procedure, we'd probably be here for 2 days. So we're having a look at more the legal issues. What you will notice in relation to each of the reasons that we discussed today is there is a heavy emphasis on reasonableness. So in relation to each reason we're looking at, whether it's conduct or performance or redundancy, the test is whether you've acted reasonably in the circumstances. So did you have a reasonable ground, a reasonable reason for dismissing? Did you have a reasonable belief in that reason? And we'll have a look at what that means in relation to each reason as we go along. So first of all, what are the reasons? They're on this slide. So I'm going to start off by having a look at conduct. Nathan will then take us through investigations. Chris will then be covering capability in relation to sickness absence. Kate will then have a look at poor performance. I will then have a look at redundancy, and Chris will sweep up with illegality and some other substantial reason. Kate will then have a look at some of the common issues that can arise in relation to any of the reasons for dismissing, including reasonable adjustments, failure to attend meetings, the right to be accompanied and the role of the companion, and grievances raised during a formal process. Chris will then finish up with a few minutes on the proposed changes regarding unfair dismissal rights and the end of fire and rehire. Although today's session is not an update on the Employment Rights Bill, these two areas do factor in quite a lot in relation to the things that we're talking about today, so we will just spend a couple of minutes on that. In relation to questions, please pop those in the chat. They are being monitored throughout the session and they'll either be answered in the chat as we go along, or we can obviously look at those at the end of each section we're talking about today. We're going to split the sessions and give you a 5-minute comfort break after about an hour or so, and we aim to finish around 11:30 or just after. So first of all, we're going to start off by having a look at conduct. As I've said, we won't be spending a great deal of time on procedure. We all know the procedure we need to follow when we're dealing with a conduct issue for an employee with unfair dismissal rights. It's set out in the ACAS code. We will elaborate on some of the aspects, but broadly, we would need a thorough investigation. We would need a formal letter inviting the employee to attend a disciplinary hearing that must include certain information, including details of the allegations, the evidence that we've gathered, and possible outcomes as well. There would be a disciplinary hearing, a decision in writing, and we'll look at sanctions later, and also the right to appeal to somebody not involved to date. Sometimes we don't have to follow this full procedure if we're looking to dismiss somebody with short service at the moment, but that is obviously set to change, which Chris will come on to later in summary. So a dismissal for misconduct of an employee with unfair dismissal rights will only be fair if we believe the employee is guilty of misconduct, and we have to have reasonable grounds for holding that belief. So at the time that we hold that belief, we have to have carried out as much investigation as was reasonable in the circumstances. And this is the test that the tribunal will apply, and they refer to that as being the range of reasonable responses test or the band of reasonable responses. So the tribunal would have to decide whether the decision to dismiss fell within that band or that range of reasonable responses, and the test for that is what a reasonable employer in those circumstances and in that business might have adopted. The tribunal will look at both the procedure that you followed and your reason for dismissal as well, and were both of those things reasonable in the circumstances. So what are some of the risk areas when dealing with conduct? Well, one of the risk areas is investigation. What amounts to a reasonable investigation? Well, Nathan's going to cover that in quite a lot of detail shortly. So what I want to flag now is just some of the legal points. So we do need to carry out a thorough investigation. We need to act promptly and without unreasonable delay. We might want to suspend the employee at this point. I'll look at suspension shortly. But how much do we need to do by way of an investigation? Well, we don't need to leave every stone unturned. The legal test, again, is it has to be within that range of reasonable responses. So a reasonable investigation in the circumstances. The more serious the potential consequences, so if we might dismiss the employee, obviously the more investigation would be required. And just remember at this stage, you would have somebody dealing with the investigation, somebody different dealing with the disciplinary hearing, and somebody different dealing with the appeal, and those people shouldn't be witnesses or involved in the allegations. And ideally, the person dealing with any appeal would be more senior than the original decision maker. One final point I just want to mention here about investigation is when carrying out the investigation, we might think, actually, is conduct really the reason here? Sometimes it's not clear if the reason for our concerns are related to the employee's conduct or related to their capability. So if an employee isn't hitting their targets, they're not doing their job properly, is it because they're not capable of doing their job, in which case it's a capability or performance issue, or is it because they're too busy on their phone using social media, etc., in which case it's a conduct issue? Sometimes it's obvious following the investigation, usually it is, but not always. And I'll give you an example from a case that we dealt with involving the hospitality industry and a manager who was working in that industry. They weren't managing their staff properly, resulting in complaints from staff about the manager and about the behaviour amongst staff as well. So was that conduct that the manager was ignoring staff issues and couldn't be bothered to manage those issues, or was it performance or capability, i.e. the manager didn't have the skills or experience how to manage those situations properly, couldn't navigate difficult conversations, and didn't really know where to go for help either. The employee didn't engage at the investigation stage, so the employer invited the employee along to attend a hearing. In the letter inviting that employee in, they explained, we're not sure if this is a conduct issue or a capability issue, but these issues are so serious they need to be addressed in a formal setting, and went on to explain in that letter that if we find that there is a performance issue or a misconduct issue, we may issue you with a written warning or a final written warning. So it was clear to the employee, it might be conduct, it might be performance, but either way it could result in some kind of formal sanction. So both bases were covered and the procedure is very similar, whichever reason is applicable. In this particular case, it became apparent that the manager was ignoring staff issues because they weren't able to deal with them. They weren't comfortable tackling tricky conversations. So it was a performance issue, and they provided management training in order to assist the individual in improving. I mentioned suspension. The tendency can be to suspend everybody that has been accused of a serious disciplinary offence. That's a mistake to take that automatic position. Before we suspend, we need to consider, is it reasonable in the circumstances to suspend? So suspension might be appropriate where, for example, if we don't suspend, there might be a threat to the business or to other employees within the business, or where it's not possible for us to investigate the allegations if the employee remains at work. For example, they might destroy evidence or attempt to interfere and influence witnesses, or we might suspend where relationships have clearly broken down. We need to be careful that we don't give the impression that we've prejudged who's to blame, and if we do suspend and we don't have reasonable grounds for doing so, that can cause problems, including a potential claim for a breach of the implied term of trust and confidence, which could lead to a resignation and a constructive unfair dismissal claim. Also, if we don't have a contractual right to suspend and we suspend anyway, then we might be in breach of contract if the employee has an implied right to work. Now, this is quite rare, but it can apply where, for example, an employee earns commission as part of their role, and if we suspend them, then they won't have the opportunity to earn commission. And in the absence of a contractual right to suspend in those circumstances, we could face a breach of contract claim for the loss that they've suffered. So in summary, suspension shouldn't be the sort of knee-jerk response. We need to think about whether it is appropriate to suspend in the circumstances. So think, is suspension actually necessary? And if so, why? Are there any alternatives to suspension? For example, could we move the employee to a different department? Speak to the employee to get their version of events, because that will help you decide whether suspension is likely to be necessary. If you do suspend, you should keep a note of your considerations which led to that decision to suspend. We would also send a letter to the employee confirming suspension and that it is a neutral act and implies no criticism of the employee. We should also keep the period of suspension as short as possible and keep it under review. So we can still suspend, but we ought to think carefully whether it's necessary in the circumstances and if there are any alternatives. So another common issue that can arise in relation to conduct is deciding whether something is gross misconduct or not. Now, the term gross misconduct describes the most serious type of misconduct, such as theft or violence, which justify instant dismissal without any prior warning, subject obviously to following an appropriate procedure. Now, what constitutes gross misconduct is a mixed question of law and fact. So it should involve either some kind of deliberate wrongdoing or gross negligence. Different employers will take different views as to what amounts to gross misconduct in their workplace. So if you have a place of work where health and safety is of paramount importance, then a breach of a health and safety policy may be more likely to be considered to be gross misconduct than it might be in a different working environment. I'll give you an example of a gross misconduct case that we dealt with, which involved an employee who worked in a yard, was driving a forklift truck over the speed limit around the yard in wet and slippery conditions. He drove the forklift truck up a ramp, didn't see there was another forklift truck already on the ramp, and drove into the back of that forklift truck, which had somebody in it. Fortunately, nobody was injured, but this was all caught on CCTV. The employee was dismissed for gross misconduct for obvious reasons, and health and safety is obviously of paramount importance in that type of working environment. The employee brought a claim, and the tribunal agreed that that was gross misconduct. So what constitutes gross misconduct needs to be considered in relation to the particular employment and the employee. So we should bear in mind that gross misconduct must be so serious that it goes to the root of the employment contract. That is, the conduct must be repudiatory, entitling the employer to terminate with immediate effect, or the conduct must be deliberate and willful breach of the employment contract so that it amounts to gross negligence. If you're not sure if something amounts to gross misconduct and you're the decision maker, it can be helpful to sense check it with somebody else within your organisation, subject to confidentiality, because it can sometimes help to have a fresh pair of eyes. In the absence of gross misconduct, the dismissal of an employee with unfair dismissal rights for a first offence is likely to be unfair if they haven't received any previous warnings. So when we're looking at the appropriate penalty and we don't think it's gross misconduct, we need to look at whether there are any live warnings on the employee's personnel file, and we can take account of those warnings if they are also for conduct. The ACAS code envisages a staged process whereby somebody usually will receive a first written warning for the first instance of misconduct, followed by a final written warning for the next instance of misconduct, followed by dismissal if there is a further lapse or within the life of the relevant warnings. So can we issue a final written warning for the first instance of misconduct? Well, the ACAS code does acknowledge that actually an employee's first misconduct may be sufficiently serious to move to a final written warning in certain situations. And the code says that might occur where the employee's actions have had or could have had, were likely to have, a serious or harmful impact on the organisation. So, for example, if an employee has mislaid confidential information, they've left their laptop on a train, the laptop was recovered before anyone else accessed the laptop, it still might be reasonable to issue a final written warning for a first offence, as there could have been quite significant consequences and quite a serious impact on the business if things hadn't turned out as they did. What about dismissing somebody with a first level written warning on file, skipping the final written warning stage? Well, obviously, if it's gross misconduct, that's okay. But what if the second act isn't gross misconduct? Well, the ACAS code is silent on this point. It might be the final written warning carries with it, either expressly or implicitly, that any further misconduct during the life of the warning could result in dismissal, whereas a first warning doesn't carry that potential risk with it, or the potential outcome for the employee. So it may be risky to move straight from a written warning straight through to dismissal, skipping the final written warning stage. You would have to look at the situation carefully and consider if the conduct is sufficiently serious to skip the final written warning stage. What about conduct outside of work? Can we take account of conduct outside of work when we're looking at disciplining or dismissing? Well, it depends. The key question is whether the conduct in question affects the employment relationship. So does the conduct in question affect the employee, or could it affect the employee when carrying out their work? I'll give an example from a reported case involving Kerry Foods. So an employee was dismissed fairly for fighting off-site with a colleague. There'd been a long-running dispute between them about a girlfriend. The fight took place in a car park across the road to the workplace. However, the employee's conduct clearly affected working relationships, as the other employee didn't feel safe to attend work any longer. The fact that the dispute arose as a result of a purely domestic matter was irrelevant, and the Employment Appeal Tribunal agreed with the first stage tribunal that the employee's conduct had broken the employer's trust. So cases involving violence, sexual conduct or dishonesty are the most likely to affect the employment relationship, either because of the nature of the work or because of general considerations about damage to reputation, which I will come on to shortly. In terms of cases with a criminal element, there's no general rule that somebody should be dismissed because they are investigated for, charged with or convicted with a criminal offence. The ACAS code says that consideration has to be given as to what effect that charge or conviction has on the employee's suitability to do their job, and also their relationship with their employer, work colleagues and customers. So if we are looking at dismissing or disciplining an employee who is subject to criminal investigation, charge or prosecution, there are some points set out in the ACAS guide which are useful, which I will run through now. So firstly, the guide says that we should consider whether the conduct is sufficiently serious to warrant disciplinary action being taken, and off-duty conduct which has no bearing at all on the employment relationship is unlikely to meet that threshold. You don't have to wait for the outcome of a criminal prosecution before taking action internally. In cases where the employee is not available for work because they're in police custody, you need to decide whether in the circumstances and in light of the needs of the organisation, you can keep the employee's job open, and obviously size of business is likely to be relevant here. Where a criminal conviction leads to, for example, the loss of the driving licence, something that's required for the job, and no alternative work is available, then it might be appropriate to dismiss, and Chris is going to talk about that in a bit more detail. And where an employee charged or convicted with a criminal offence refuses or is unable to cooperate with your disciplinary investigations and proceedings, that doesn't have to deter us from taking action. The employee can be advised in writing that unless further information is provided, a disciplinary decision may be taken based on the evidence available. They can always liaise with their solicitor as well, and we can ask them to prepare a statement with their solicitor. So is criminal conduct relevant to the nature of the work? Well, an example from a case involving an employee working in a department store. This supervisor was fairly dismissed after it was discovered that she had shoplifted from another store nearby. The tribunal said it would be unreal to expect the employer in the retail trade to overlook that shoplifting. In relation to a case that we dealt with, an employee was found to have pornographic material on their laptop. They were arrested. They worked with young children. The CPS were prosecuting. They were dismissed. The employer relied on information gathered by the police. No claim was brought, but if a claim had been brought in those circumstances, most likely it would have been a fair dismissal. I mentioned reputational risk as well, quite a severe example from a reported Court of Appeal case. This involved a senior civil servant working for a high-profile public authority. That person was fairly dismissed after his employer discovered that he was being investigated for sexually abusing children. He denied the allegations, he was never convicted, and the allegations had no direct bearing on his work, but it was fair for the employer to dismiss in the circumstances due to reputational risks. What about cases involving social media? Well, the concept of conduct damaging our reputation, even if conduct takes place outside of work, is particularly relevant when we are talking about social media. So usually people access social media in their own time outside of work, but the reported cases in this area suggest that whether the employee's use of social media is work related will depend on the facts of the case. Also, we shouldn't take a disproportionate view of the damage or potential damage to our reputation just because the conduct doesn't perhaps paint us in the best light in the public arena. And also, it's important to look at what information has been given to the employee about our corporate image and our reputation, and also our expectations in terms of use of social media. Again, a couple of examples from reported cases. The first involved Summerfield. So in that case, it was unfair for Summerfield to dismiss a manager for posting a fairly innocuous video on YouTube of an employee in uniform being bashed over the head with a carrier bag, a Summerfield carrier bag full of other carrier bags. It only received 8 hits. It was taken down by the manager after 3 days, and he apologised for his error of judgment. And it was found that was outside the range of reasonable responses open to the employer to categorise that as gross misconduct. And I think we can all see why. In a case involving Asda, I'm not sure if there's a supermarket theme going on here, but a tribunal found that comments made by an Asda manager on her Facebook site, where she said it would make her happy to hit customers on the back of her head with a pickaxe, constituted misconduct rather than gross misconduct, and the dismissal was therefore unfair. It was significant to the tribunal that the conduct list in the employer's disciplinary policy listed misuse of social media as being an example of misconduct and not an example of gross misconduct. To give an example of a case where use of social media did result in a fair dismissal is the case involving Apple. An employee who worked for Apple posted on their Facebook page, once again, F you very much work, and what's that, an Apple product going wonky, surely they can't do that. The dismissal was found to be fair in the circumstances, and it was critical to the tribunal's decision in that case that Apple had made it clear in its policies and training materials that protecting the image of the brand was a core value and was fundamentally important. And they had also drawn attention to the fact that making derogatory comments on social media about Apple and the Apple brand was likely to constitute gross misconduct. So it's really important we make sure our social media policies are clear on our expectations of employees and what is likely to amount to misconduct and gross misconduct. I'll now hand over to Nathan to come and talk about investigations.
Good morning, everyone. For those who don't know me, my name's Nathan. I'm the head of HR services. I work alongside Chris, Michelle and Kate, providing HR services to our clients. This morning, as Michelle said, I'm going to talk to you about the investigation process, and we'll focus very much on handling and investigation. So the starting point for any good investigation is for the investigating officer to formulate an investigation plan. The investigation plan should clearly set out who the investigating officer will be, the terms of reference for that investigation, a provisional timeline for the investigation, albeit that timeline may change depending on the complexity of the investigation itself and the matters under investigation, but setting out a provisional timeline is helpful in keeping you on track. Again, in the investigation plan, you should clearly identify any relevant company policies that you want to refer to or rely upon throughout the investigation, including your procedures which apply to the specific matter that you are currently investigating. Issues which need to be dealt with should also be clearly identified and addressed within the investigation plan. And you should also give consideration to the types of evidence that you might want to collect throughout that investigation process. That may include things such as witness statements, CCTV footage, copies of relevant documentation, or indeed even things such as IT access logs. You should clearly identify the people who you will need to interview as part of the investigation process and make the necessary arrangements for meeting with those individuals at investigation meetings, including the logistical arrangements such as timings of meetings, a meeting room being available for you to meet with those individuals in a confidential space, and any special arrangements you need to make for individuals who may have particular needs. It's an important point in the investigation plan that you should clearly set out a start date and an end date for your investigation that aligns with setting out a timeline, just so that you can manage everyone's expectations around when the investigation is likely to be completed and your investigation outcome report is likely to be available for decision makers to review. So I just want to touch on HR's role in the investigation process itself. Case law has made it clear that HR practitioners should not be overly involved in the investigation process itself unless you as an HR professional are leading the investigation as the investigating officer. It's for the investigating officer to carry out their own investigation and to essentially reach their own conclusions based on the evidence that they gather as they work through the investigation process. The investigating officer should then, following conclusion of the investigation, draft their investigation report. They should summarise the evidence that they've gathered. They should also summarise the process that they followed throughout the investigation process itself. And they should then make recommendations in their report as to what action should be taken, if any. Again, it is really important that as HR practitioners, if you are supporting the investigation process, that we're not seen to be unduly influencing the investigating officer or their findings or their decision making as part of that investigation process. So I want to talk a little bit about the investigation process itself. So a good investigating officer will be thorough and considered in their approach. They will not adopt a kind of fly by the seat of your pants approach. It should be, when you adopt, when you're conducting an investigation, you should be considered. You should make sure that you are organised and that you are going to do justice to the investigation. Now, not all investigations are made equal. Some will be more complicated and complex than others, and that should influence the amount of work involved to work through that process and to reach its natural conclusion. An investigating officer will be, as I said, will be considered. You should avoid going down rabbit holes, and that's where it's really important for you to set out clear terms of reference at the start of the investigation so that you can keep yourself focused on what is relevant and what needs to be established as you work through the process. HR professionals should meet with the investigating officer if you are indeed commissioning that the investigation itself, and you should help the investigating officer understand what is required of them. Often there will be times when the investigating officer will be a line supervisor or a line manager, and they're likely not to have the same level of experience or potentially skills that we have as HR practitioners in conducting the investigation. So therefore, it is our responsibility to help support those individuals in setting out what they need to do. And again, referring back to formulating a detailed investigation plan, that will be really useful in helping a line manager work through the process, knowing quite clearly what they need to achieve. Now, Michelle's already touched on the investigation needing to be reasonable, and I just want to reiterate that a good investigation will make sure that you inform the employee who is subject to the investigation that they are under investigation and that an investigation will be taking place. You will adopt a reasonable time frame. Again, the time frame will be very much dependent on the matters under investigation. If a matter is relatively straightforward, the investigation will be usually quicker and shorter, but obviously if it's a complicated matter, then it may be that you take a longer period to be able to work through that process. You should always follow your internal procedures wherever necessary. I can't emphasize that enough. And you should focus on establishing facts, not opinions, as you work through the investigation process, and you should absolutely be mindful of confidentiality. So I do want to touch on maintaining confidentiality and protecting witnesses, including handling reluctant witnesses in a little more detail. So confidentiality should be at the heart of the investigation process itself. This is very important. The investigation process should be as confidential as it possibly can be, and information should not be readily shared unless it's necessary with appropriate people. Again, those people can be identified in the formulation of your investigation plan. Every person spoken to as part of the investigation process should clearly be told at the outset of any investigation meetings that what is discussed during those investigation meetings is confidential, that it should not be discussed outside of the investigation meeting itself, and we should put people on notice that if they were found to be breaching confidentiality, that they could leave themselves liable to disciplinary action for doing so. And I think it's really important at the outset that you make that clear to all individuals you are speaking to. Treat witness statements as confidential. That's important. We shouldn't give an absolute guarantee to parties that we're speaking to that we can maintain confidentiality or protect their anonymity. Essentially, if we're gathering witness statements and we're going to rely on those witness statements as evidence, we want to be able to present the evidence we gather as part of the investigation process to the person who's subject to the investigation. They should be able to see the evidence we've gathered and to potentially test or challenge that evidence in a meaningful way. So beyond, making reasonable redactions, if there was a need to protect third-party information, for example, I would always advise that we be very considered if somebody asks us, for example, to anonymise a witness statement. We should communicate with that individual, ask them for what the concerns are and why they feel that their witness statement should be anonymised, and see whether we can work through a process whereby we can reassure them that there will be no repercussions for them participating in our investigation. That being said, if an individual raises genuine concerns about there being potentially reprisals for them participating in the investigation, and we can't actually allay their fears, then what we should do is give consideration to whether we do anonymise that witness statement and or whether we indeed redact. and if we are going to make redactions, again, what is reasonable in the circumstances. I would now want to talk about protecting the, handling reluctant witnesses. Oftentimes, and I've experienced this myself many times over the years, that there can be witnesses who are uncomfortable about participating in an investigation process itself. Again, if I encounter that, what I like to do is to sit and talk with the individual to understand what their concerns are. I always communicate with them and explain that actually their contribution, I think, could be helpful to the investigation process. I try and understand, specifically what do they think the outcome of their participating in the investigation could be, so I can try and manage that in a proactive way. Ultimately, we cannot force anyone to share information with us. All we can do is approach people in a meaningful way and set up what we're investigating, what the investigation process will look like, and what support we can give that individual to take part in the investigation itself. So I want to talk about holding the investigation meetings that you would need to chair with individuals as you work through the investigation process. So there are things that you can do before the investigation meeting which can help you get the best out of interviewing your witnesses. So I always recommend that you plan questions in advance which you want to cover with witnesses. This helps keep you focused, it helps keep the investigation meetings short and concise, and it also helps you gain the relevant information. That being said, it may be that as you work through your question framework with witnesses, that there may be additional questions you want to cover off with them if they share anything that is particularly relevant that you want to gather or gain further information on. So you should be prepared when you work through the investigation meeting itself to ask additional questions if need be, but not to stray too far from your pre-planned set of questions. Before the meeting, as I've said before, make the logistical arrangements, make sure that you've got everything you need ahead of that investigation meeting, so that when the person joins the meeting, you've got everything you need to conduct a reasonable meeting with that individual to get the most out of your time with that person. Wherever possible, I prefer to write to attendees and invite them to an investigation meeting. Although that is not necessary, you can simply invite someone into an investigation meeting to ask them the questions that you want to cover off. But my preference is to try and give someone as much notice as possible so that we are working with them in a reasonable way. At the start of the investigation meeting, you should clearly explain who is present and why. For example, if you're the chairperson of the investigation, you should set that out. You should explain if the note taker is present and what their role is within that meeting. The investigating officer should also cover confidentiality and the possible consequences for breaching confidentiality. And they should also cover off who will see the notes or any witness statement that will be produced from that investigation meeting. That's a particularly important point as it helps avoid protracted discussions following that meeting when you want to include any evidence you've gathered from the investigation in your evidence bundle at the end. So we should make it clear to all people participating that potentially anything that they say or share with you will be shared with the person who is subject of the investigation. During the investigation meeting, questions should be asked which are focused on getting facts, not opinions. That is particularly important. Hence why we always advise that ahead of any investigation meeting, you go in with a prepared list of questions. As an investigator, you should probe, but not be aggressive or adversarial in your approach, as that can often be intimidating and can mean that it will shape or influence the quality of the information that you gather as you work through your investigation process. If the attendee refuses to answer questions, you could probe as to why they're not prepared to answer specific questions. However, if they continue to resist answering any questions, you should make notes of this in your either the meeting notes or any statement that you produce following that meeting. You should also look for opportunities to find evidence which can substantiate what is being said. So be curious in your approach. Don't be frightened to go beyond your list of questions if it's helpful and it's going to help you gather relevant information that you may want to take into consideration when you conclude your investigation and you think about making recommendations for any decision maker following that process. At the end of the meeting, you should ask the attendee if they have anything they want to add, or if there's anything they feel that they've not shared with you which is important or relevant. Ask the attendee if there are any other people they think should be interviewed, so anybody they think you should speak to gather further information that may help you conduct your investigation. That's particularly important, and any responses they give to you in regard to that should be clearly noted down. You need to explain that you may need to arrange a follow-up investigation meeting if you have further questions. So again, just put people on notice that as the investigation is ongoing, it may be that you need to refer back to them and make them aware of that, so that if you do need to do that, it doesn't come as a surprise. And explain that they will receive a copy of the notes from their meeting. This is particularly important once you conclude your investigation meetings, is to share those notes with the individual and ask them to review them and confirm that they are happy that they serve as a fair reflection of the key discussion points from your meeting before that is entered into your evidence bundle. So just covering off questions you should, or questioning techniques, I should say that you should adopt during the investigation meeting itself. Obviously, always ask open questions wherever possible. You can ask closed questions when you want specific answers in relation to any question you're covering. Probing questions to test evidence, but again, remember not to be aggressive or adversarial. Feeling questions, they're not always necessary, but examples can include: what concerned you about Jane Doe's behaviour? Why did you feel that you had to step in and intervene, for example? That can again give you more context and helpful information that you can take into consideration as part of your investigation process. You could also consider asking what else questions. These are to make sure that you have all the relevant information to hand. So examples of that could be: do you remember anything else about the way Jane was behaving during the morning? Is there anything else you think I need to know as part of the investigation process? Again, hopefully that'll help you gather more relevant information for your investigation report at the end of the process. And once you work through to the end of the investigation meeting, you should summarise what's been discussed and ask if you have understood everything that has been explained to you. So giving that summary back to the individual helps them understand whether you've heard them correctly and that you've not misinterpreted any of the information that they have shared. Finally, I want to talk to you about the investigation report itself. This is a particularly important document that you will want to make available to any decision maker once you've concluded your investigation. So as the investigating officer, you should be looking to make recommendations, normally at the end of your investigation process, and these recommendations should be made in the report. Your recommendations should not go beyond identifying whether formal action is required, whether informal action is required, such as mediation or further training, or whether indeed there's no action required following the investigation. But your recommendation should not go beyond that. If you believe that formal action should be taken, then you should make clear in your report that the matter should be referred to a disciplinary officer along with your report and along with the evidence you've collected, for them to consider your findings and then to take the process forward. Remember, as investigating officers, we're not decision makers, we're purely fact finders who are responsible for gathering evidence and setting out that evidence in a way that is meaningful and easy to interpret and understand. The investigation report itself should be clear, concise, and it should also be objective when setting out the facts and your findings from the investigation. ACAS recommend that we avoid using things like nicknames or jargon. We should use simple and appropriate language in the way we write and communicate. We should stick to the facts always and should not deviate from that. We should include all the evidence that we've collected. Typically, we should list that in the appendices at the back of the investigation report, so that any decision maker who's going to rely on the report can clearly see the evidence you've gathered and the evidence you refer to during the report itself. A good investigation report should be structured, and it should typically have an introduction, an outline of the investigation process that you have followed. It should have your findings, a conclusion, and it should have your recommendations. Thank you very much. I'm going to hand over to Chris Dobbs.
So I'll leave you there, Nathan, because we just had a couple of questions came up. I'll come and do them to you personally, because
Fine.
saves us having to relay them across the
Yes.
room. So the first question is kind of about the role of HR in maybe the note-taker advisory role. So it's two related questions. Is it okay for, so I suppose the first question is, should HR be the note-taker at an investigation meeting?
Well, I mean, that's not unusual if you've got a competent investigating officer who is able to lead on that meeting and not necessarily going to rely on you to help shape or conduct that meeting. Then absolutely there's nothing wrong with an HR professional taking notes and making those available at the end.
Yeah, but obviously no requirement for it to be somebody who's HR trained.
No. As long as they're competent and they can take notes, then yeah.
Is it okay for that person, assuming it is, say, a HR professional, for them to then also be at the disciplinary hearing to do the same role as a note taker, whilst also kind of being in that advisory capacity that you sometimes find yourself in process?
My preference is always to split those out. If someone is giving advice or supporting in a more advisory capacity, and that goes beyond simply taking a record of the meeting. So I would suggest, wherever possible, you would separate those roles out so you haven't got the same people involved at the late stage.
Yep, and unrelated question, any process, rules, advice, tips for inviting an employee to attend a disciplinary hearing, assuming it's the one under investigation, who is currently on annual leave?
Well, if someone's on annual leave, my position would be we'd allow their annual leave to conclude, we'd invite them to the hearing once they've returned to work, and we'd make sure we give them sufficient notice. So, for example, if there's information that they need to review ahead of that meeting, we don't want to invite them to attend a hearing on the first day back from leave. I would suggest we would do it mid towards the end of the week so they've got time to prepare.
Excellent.
Thank you very much.
Those are the questions I have.
Thank you.
Yeah, if anybody does have questions as they go, I put it in the chat. I was the one answering them, so obviously I'm not in a position where I can currently see them, but please do keep going. We'll address any more questions at the end. I think one of my colleagues has just gone over to take a look and take over if they can work it out. So I am left with, ironically, capability, having just made that joke about one of my colleagues. If we are looking at Section 98 of the Employment Rights Act, which of course is where we're concerned about the things that allow us to fairly dismiss somebody, it tells us that one of the potential fair reasons under subsection 2 is that, quote, it relates to the capability or qualifications of the employee performing work of the kind which they're employed to do. This is then subdivided by the statute itself into two particular sort of sub-justifications. Capability, there's the fire alarm that those of you who do our coffee break briefings will be used to, so I will just pause while that rings for a few seconds. For the benefit of the recording, I'll now cut back slightly so that marketing can pick this up and make it look like a smooth recording. This is then subdivided by the statute itself into two sort of sub-justifications. The first one being capability, meaning the skills, the aptitude, the health-related performance issues that I'll be talking about, and separately then qualifications, which helpfully under the legislation means they're qualifications. The second of these I'll address very quickly first. It's not something that Kate or I will be talking about in a huge amount of detail, although technical and academic qualifications will sort of fall more under Kate's than mine. But beyond short service dismissals, these sort of academic technical qualification dismissals are actually quite unusual. Generally, I think it's fair to say that these issues will be discovered well within the first 2 years, although of course watch this space at the moment on that, or equally these days, and particularly I think in certainly since 1996, are going to be picked up much more earlier at recruitment stage. We find out much earlier whether somebody does or does not have a technical or academic qualification. That said, a lack of qualification can lead to a fair dismissal if an employee has purported to have qualifications that were essential for the job, and then it's later discovered that they don't. The other situation where this potentially arises, of course, is if somebody is employed with the purpose of getting a qualification. Trainees in certain roles, I'm not looking at ours out the corner of my eye here, and then for whatever reason don't do that exam, don't pass the qualification. They obviously then can't be employed in the substantive role. They're not qualified to do it. Using that first example where somebody has purported to have that qualification, of course, that is also likely to be a breach of contract. It's a conduct issue and may also be some other substantial reason, which I'll come on to towards the end of this morning. Another example, of course, of a potentially fair reason for lack of qualification, and I promise Michelle and I did not coordinate topics when we were planning this, is if somebody had a dedicated qualification, such as a forklift license, and then lost it for, by example, racing it insanely through a courtyard. Again, this could also amount to illegality and SOSR, both of which I'll come back to later in this morning's session. We're then concerned for the first half of today between Kate Shortley and I with the other two, really. Ill health issues, capability, so meaning the employee's physical or mental health affecting their performance and ability to do their job, often by way of absence, and skills related, meaning a lack of aptitude or competency. So I am left with ill health capability. So starting with possibly the more problematic of these two, ill health and capability, broadly the employee's inability to perform their job due to ill health reasons, usually a deterioration in performance, very commonly an ill health absence situation. often, as I've said there, similarly referred to as medical incapacity. When considering an ill health issue, we should be aware of all relevant factors. You will get bored of the word reasonableness today. It's going to crop up a lot. But do remember that that underlying basic test for any dismissal hinges on fairness and reasonableness. The underlying justification in an ill health dismissal, as with almost any other dismissal, will be whether as employers we've acted reasonably and fairly in concluding that the ill health issue exists, that it is affecting performance, stroke attendance, and that we are reasonably concluding that dismissal is a reasonable response. So what we want to be thinking about, particularly in use of the medical evidence that we may have access to, is the duration of the absence, the duration of the illness itself, the prognosis and how long those two issues are likely to last, which may require specific medical evidence in its own right, any possible adjustments and any possible support mechanisms that we may be able to implement. As I've hinted there on the bottom of the slide, this is one of those areas where we also need to be conscious of discrimination, particularly where the ill health is potentially caused by a disability, and I will come back onto that in more detail towards the end of this session. When we're thinking about some of the legal issues then that result in ill health capability situations, the first thing to note actually is around ACAS and the Code of Practice, Code of Conduct there. It's something we often harp on about a lot, particularly when we're talking about conduct dismissals. Strictly speaking, the code relates to fault-based dismissals. It therefore may be much more relevant to when Kate starts talking about capability, but has much less impact on us when we're talking about an ill health dismissal. I think the reason that most of us struggle with ill health capability compared to other forms of dismissal is there's not an element of fault there. We can't point at the employee and saying, you're doing something wrong. And the code kind of reflects that. The Code of Conduct is concerned primarily with disciplinary fault-based issues. That said, we don't want to completely ignore the code. We don't want to completely ignore process and procedure, of course, and ACAS do have a lot of guidance on ill health dismissals and capability issues. So the underlying reason, as I keep coming back to, we look back at that statutory definition. Is the employee no longer capable of performing work of the kind that they were employed to do? And that is ultimately an ill health capability dismissal. This means that absence due to sickness is a potential fair reason for dismissal. The employee is no longer ready, willing and able to do their work. Similarly, capability short of an absence affecting exactly the same problem. Long-term absence itself can also be a conduct issue. So it's important, as Michelle was certainly hinting at earlier, or certainly categorically saying earlier, I would say, to decide which route you're taking, because the code, your process, your legal thresholds will change, and they are different whether you're taking a conduct or capability approach. It's rare, in my opinion, that an ill health dismissal will fall under the conduct side of things, but it can happen. It's perhaps much more likely where there is arguably some element of fault. An ill health absence or deterioration in somebody's ability to do their job that's caused by a sporting injury that was their own choice, or perhaps as the result of an at-fault car accident. Relevant factors when talking about ill health dismissals and capability issues: the length of the absence or the likely length of the absence, stroke ongoing performance concern. The length of the individual's employment, we know that 2 years is potentially relevant for the time being, but equally a longer term employee who has been of value to the business on a short term period of absence is less likely to be fair and reasonable to talk about dismissing them. The likely level of ongoing absence, of course, that's bound to be relevant because it will pull into your question of how the employee is likely to be able to continue to perform in the future. And equally the needs of the employer. Again, looking back at that statutory test, it's all about, can they do the work? Is it something that they are able to come back and continue to perform in a way that we need them to do so? And that is ultimately a question of your needs as the employer, and it is a relevant factor and therefore should be part of the decision-making process. And as we keep saying, this comes back to reasonableness and fairness. So this does come down to documenting your thought processes and your decision-making approach. If an individual in perhaps a smaller organisation or somebody quite high up in the business is causing a particular problem by being absent, that is a relevant factor compared to somebody for whom maybe there are 20 or 30 people doing their job. So case law suggests that the basic test over absence in particular is a question of could the employer have reasonably been expected, that word again, to wait longer for the return to work. Consider therefore the difference between somebody who is off work due to perhaps a broken limb, where at the point of 2 or 3 months it could be another 2 or 3 weeks, and one of those more undefined absences, or where we've got longer periods of absence, which are particularly common, as we all know now, with perhaps mental health conditions. In terms of fair process, therefore, we're looking at an understanding of the absence or drop in performance, its cause, its length, and giving the employee that reasonable opportunity to improve, return to work, or improve their performance. Remember that when following any absence process, the starting step should be around identifying ways of ending that absence. And similarly for performance that is short of absence, it's about improving the level of work and getting the employee back to work. At the end of the day, we don't want to be terminating somebody who we have invested in, who does bring value to the business, and then having to go through a recruitment process if there is a way of bringing that individual back into the workplace and performing to standard. Unlike, as I know unofficially happens in conduct cases, we do often set out with a view of dismissing, even though we will swear blindly we don't. That is not the approach we want to be thinking about at all in relation to sickness, absence and capability issues. Procedure, therefore, will normally involve several stages. At each stage, the employee should be given the opportunity to make representations at a meeting. They should be allowed to be accompanied, which we'll come back to in some detail later in the session, should they choose to be so. They should be given appropriate notice of that meeting, told what's going to be discussed, and that meeting should be documented. It should be followed up in writing, detailing what was talked about, and what, if anything, needs to improve. That could be some realistic attendance setting. It could be another objective measure of performance. They should also be aware at all stages of the possible consequences of failure. It's always part of the reasonable and fairness test as to whether an employee understood that dismissal was a potential outcome of the process. Moving on to some of the legal tests and how the tribunal approach this, and I'll move on to medical evidence in a little bit of detail in a moment. So the first test that we got up on the slide there, this is simply a reasonableness test considering medical evidence and the effect of absence on the employer. That is the test that broadly applies. Waited longer there before dismissing is obviously specific to ill health absence, but it is a version of that underlying was it reasonable in all the circumstances to dismiss test that applies to all dismissals. Second point there, as with all dismissals, there is that obligation to engage with the employee. If they refuse to engage, you need to base your decision on the circumstances as you know them, the information available to you. The employee's failure to engage can count both ways depending on the circumstances, and I know that's something that will be discussed later in the session. Finally, as I said, more on medical evidence in a moment, but I think it's always worth bearing in mind when we're talking about an ill health dismissal that it's going to be hard to justify a dismissal with absolutely no medical evidence in front of you. So taking steps to try and discover what that condition is, what it's about, and the likely prognosis is always going to be important. So what can we do in terms of medical evidence? As I've just said, it's pretty much fundamental to establishing the fairness of an ill health dismissal, as it will dictate the reasonableness of your responses as an employer and go to the considerations that you're making at the time. You're looking for any information which helps you form a view of the condition itself, the likely effects on the employee, in particular prognosis about return to work and or return to some form of standard, and their ability and their capacity to carry out their primary job role. Evidence can be usefully sourced from the employee's primary medical practitioner, of course, but be mindful that under Access to Medical Reports Act, this requires specific consent. There are also a lot of practical considerations here around accessing medical reports. We've all had it, particularly when acting for a claimant, but equally when acting for a respondent, you end up potentially with 300-400 pages of completely irrelevant medical information, which is of no help to you. And more importantly, the employee probably doesn't want you to see their unrelated medical problems from 5-10 years earlier. Therefore, due to the potential difficulties of obtaining that particular medical evidence, of filtering through it, the employee's reluctance of their line manager reading about all their ill health conditions, occupational health is often preferable and is often what we would suggest in most cases. This will, of course, ordinarily be at cost to you. Very unusual to ask an employee to make those payments, although that's a matter of contract as much as anything else. You do still need to obtain consent for that referral itself. But the counter to all of this, it's the occupational health specialist who then has access to the medical record they need. It's not you. This is going to be more amenable to the employee. It's easier for you, of course. You will get a summarised report from the occupational health practitioner. And it sort of gets things away from the line manager having to filter through a huge amount of information, do additional work, and inevitably be obstructed in the process. It also gives you an opportunity to pose some of those specific questions to the occupational health specialist about prognosis, about workplace adjustments, and the feasibility of a return and what that might look like. At some point in the last few years, it was a while back now, it may have even been during COVID, we did do a very long recorded session with an occupational health specialist. We had a barrister on the call as well, giving various inputs around mental health, disability, and ill health capability. It's on YouTube, it's on the Fretton's page. Please do have a look at it. It was quite a good session. I thoroughly enjoyed doing it. It's still in date as far as I'm aware from a legal point of view. Do bear in mind on the subject of occupational health reports that continues to be the employee's personal medical data. They have the right, even once the medical report has been produced, to refuse for that to be shared with you. It doesn't matter that you've probably paid for it, they've got that right. On the subject of medical information and the standards on you in decision making, then judges do not expect you to be medical experts. This cuts both ways. They don't like employers disregarding clear medical guidance about return to work, about potential adjustments, without a very good objective justification for doing so. On the other hand, they also don't expect us as employers, you, to discern a course of action based solely on complicated and particularly conflicting medical evidence. Those of you who have done OH reports will have asked that question, do you think it's likely to be a disability? And the response you probably had from the occupational health specialist will be, yes, we think it might be, but that's ultimately a legal decision. That's absolutely true. The test of a disability is ultimately for a judge to decide, and it's a similar point here. The decision to dismiss is a managerial one, not a medical one. You don't ask the employee's doctor, should we sack this person? You ask them about the background circumstances, and then you make the decision as the manager, as the employer. That said, if you've got conflicting medical evidence, the employee saying they're desperate to return, but their doctor saying they're not able to do so, their doctor saying one thing, the specialist or the OH saying something else, that is a decision you then have to make as to which of those you're going to take into account when reaching your decision. You can make your decision based on the clinician's specialism, for example. That might be a relevant factor, or as part of any number of other factors, including your own business position. As long as the decision you make is reasonable in the circumstances, is fair, and takes into account what needs to be taken into account objectively, that is ultimately a decision for you. I can't talk about ill health dismissals without talking about disability and reasonable adjustments, of course. So, brief summary there, Section 6 of the Equality Act, the definition of a disability, a mental or physical impairment. I accept that impairment is perhaps unfortunate language a few years after the Equality Act was drafted, but that's the language we're left with. The test of an impairment is actually really kind of a combination of the other two halves of the test anyway. A diagnosed condition will be helpful in establishing whether it's likely to be a disability, but it's not a determination. A diagnosed condition is not automatically a disability, but equally not being a diagnosed condition doesn't mean it's not one. Long term means the condition has lasted or is likely to last at least 12 months at the relevant time. So that's when we're making the decision, when we're talking about implementing adjustments. This is why prognosis of the condition is so important, and why dealing with ill health issues is so important to do so quickly. If the condition has not and will not likely affect that individual for 12 months, it's not a disability. The impact on normal day-to-day activities is then the bit that is most hotly contested when we're dealing with disability claims. The test of this is what a claimant cannot do, not what they can. So therefore, the claimant will be evidencing things that they struggle with, particularly compared to others who do not have that disability. But what they'll also do is compare themselves before and after acquiring the condition. And it is relatively simple, normal day-to-day activities. going to the gym, taking the dog for a walk, going shopping, all relevant considerations, all normal day-to-day activities. That, of course, can be quite a difficult test when we're talking about mental health, neurological conditions, so therefore we're probably going to be considering consequences of the condition, social interaction, how the individual perceives things that those of us who are neurotypical may not. Obviously, we can see that disability is always going to be relevant potentially when considering an ill health process, particularly in relation to dismissal, where a disability may be triggered. Firstly, if we know about a disability and the absence or a reduction in performance is caused by difficulty in accessing work, we may need to consider duty to make reasonable adjustments under the Equality Act. Reasonable adjustments apply to the method and environment of work, as well as to processes and procedures. It may well be discriminatory to dismiss an employee for ill health absence or ill health capability if a reasonable adjustment could have been implemented to mitigate the absence or reduce the capability problem. Equally, there is an expectation that any process or procedure, so this is the sickness absence process, for example, is adjusted to accommodate the needs of someone with a disability. If your usual process is to provide information in writing, then consider how a huge amount of data, a huge amount of documentation sent to someone with anxiety may be interpreted, or how it is presented to someone who has perhaps dyslexia. Any adjustments, as I've indicated there, must also be reasonable. In other words, they have to actually alleviate the disadvantage that is being suffered by the disabled person. It's not just changes they want. The case law is very clear on that. It's things that will help. Reasonableness, I told you you'd get bored of this word, is also a circumstantial term. Larger and better resourced employers are expected to do more generally than smaller, less well-funded organisations, particularly if implementing the change would be a more substantial problem to the workplace. To be clear, this does not mean that cost alone is reason to not implement a reasonable adjustment. It's only a factor in a wider test of reasonableness. Worth highlighting now, the risk of discrimination, especially around disability, applies to all forms of dismissal, so do be conscious of them even in conduct cases. It can well be that something perceived as conduct is being caused by a disability. Ill health dismissal in particular does also carry the risk of discrimination claims which are indirect or which, section 15, they arise from the disability. This is particularly the case where sickness absence arising from disability is factored into a level of absence test, if the decision is then made without some kind of justification. So these are our Bradford scales, Bradford factors. They are a risk area, and care should be taken to make sure that you're not simply blindly applying them. 15 days absence equals dismissal, for example, is going to be potentially discriminatory if half of them are for chemotherapy treatment. There needs to be an extra step in that consideration, in that thought process, factoring in that some of the absences may be caused for disability. It is still possible to terminate in those circumstances. It is still legally possible, but that extra step, that decision-making process, that documentation of the decision-making is going to be key. In short, bear in mind that in capability dismissals, there is that extra burden on you to consider a disability if one arises in the circumstances. Over to you, Kate.
Thank you. It's Chris. For the next part of the session, we're focusing on continuing to focus on capability, and this time specifically on poor performance. We all know there are 5 potentially fair reasons for dismissal, and one of those reasons is capability, as Chris has just told us. Whether a dismissal for reason of capability is fair will depend on the reasonableness, that word again, of our decision in all of the circumstances, and of course on a fair procedure being followed. We'll come on to how we issue warnings and fairly dismiss for poor performance shortly. But I'd first like to look at how we can try to avoid getting to that stage, and this of course will form part of whether we have acted reasonably in all of the circumstances. First of all, we should make effective use of probationary periods for new employees. You can use this period to effectively assess a new employee's suitability for the role. The risk of a claim, of course, during the probationary period is lower. The employee will not have the usual unfair dismissal rights. This is subject, of course, to
what Chris is going to update us on at the end of the session. We know this doesn't mean we're off the hook completely. Sometimes an employee can claim unfair dismissal without any length of service, such as if they claim they were dismissed for making a protected disclosure under the whistleblowing legislation. There are also other claims, of course, that employees do not need any length of service to bring, such as a discrimination claim. So if you do want to dismiss an employee in their probationary period, you will still need to go through a checklist to ensure there are no other potential claims. However, generally speaking, it is much easier to deal with employees during the probationary period than it is once they have obtained unfair dismissal rights. And this, of course, will be even more important in the near future. Let's have a look at identifying. Sorry, my slides aren't clicking over. We're just having a technical intervention. Do I need to use this? Okay, apologies. Identifying poor performance. First of all, what are the signs of poor performance? We will look for declining work quality. This will often be the most obvious. Mistakes, errors, missed deadlines. There are behavioural signs such as lack of enthusiasm or disengagement from your employee. And consistency. Is it a one-off error or are the performance problems ongoing? Next, you will want to look at evaluating the cause, because understanding the root cause of poor performance is crucial. There could be personal issues, of course, or it could be down to lack of training, unclear expectations, poor communication, or even issues within the team, such as a clash of personalities. It could also be linked to problems at home or an unknown health problem. You should be particularly alert to the following potential issues, as they could result in claims being made by the underperforming employee. And these are things around ill health or disability, poor management within the team, harassment or bullying, or excessive workload leading to an inability to deliver, and also stress on the employee. Let's have a revisit quickly, capability versus conduct. I know Michelle has already been through this. Let's remind ourselves it is important to distinguish between performance issues arising from capability and those stemming from conduct. Capability, of course, refers to an employee's ability to perform tasks due to factors like skills, experience, or health. Conduct, of course, relates to the employee's behaviour, and Michelle has already been through this. Next, we want to make sure that we address any issues early. Don't wait for it to escalate. It's easy to overlook small issues, hoping they'll resolve themselves, but of course, ignoring poor performance can lead to bigger issues down the line, and they will be much more difficult and more time-consuming to deal with. Training and support at an early stage can result in a positive outcome, saving the time and cost involved in a lengthy and time-consuming performance management process. Use regular check-ins and feedback, as they can be a key tool in preventing poor performance. They can be informal conversations or they can be structured one-to-one meetings. They'll give you a chance to gauge your employees' progress, offer support, and address any problems before they become significant. Any appraisal system you may have can be invaluable in motivating staff, identifying issues at an early stage, and provide later evidence of performance issues if needed. But to be effective, appraisals do need to be conducted honestly. We often deal with employers with underperforming employees, but appraisals have not reflected this. And this can lead to evidential issues around a fair dismissal if that does become necessary later on. So how do we manage performance fairly? We've identified there's a performance issue and we've also identified the cause. What next? We will need to manage the performance and we'll need to have a reasonable belief based on reasonable grounds that the employee is not performing their role. So it's exactly the same as Michelle talked about in relation to conduct. How will we show that? Well, we will need to gather evidence of incapability, and we will do that by carrying out a reasonable investigation. And this is true of before embarking on any course of action. We should carry out an assessment or investigation, provide the employee with the findings of that investigation, and allow them the opportunity to respond. That's the basis of any fair and reasonable process. To gather evidence, we may look at the employee in question's job description or contract, any training records, any past performance appraisals, employee targets, staff handbook, operating procedures, or any previous performance management plans. We may also speak to any other managers involved in supervising the employee in question. Initial investigation may, of course, reveal underlying reasons for the underperformance, which need to be considered before deciding on the next step. Usually, although not strictly necessary, the fairest course of action would be to speak to the employee informally in the first instance. I say this is not always necessary. You could proceed with the formal process, which I will come on to immediately after your investigation. There will be times where this is appropriate, but it will be a question of fact in each case, and it will usually be fairly obvious when it's an appropriate course of action. However, wherever possible, it is better to have an informal chat first, because where there are issues regarding lack of training, ill health, or bad management, these, of course, can be addressed. In any informal meeting, you would also explain to the employee the improvements that are required and within what timescale. You can also make it clear that a failure to improve may lead to formal action. As I said, you will need to give the employee a chance to improve before embarking on a formal process. And we need to think about what is a reasonable timescale for improvement. It's a fact-sensitive question, and it will depend on the circumstances and the role in question. Not very helpful, I hear you say. However, it's often sensible when addressing that question to think about linking the timescale to a natural part of the business cycle, for example, a sales target period or the duration of a particular phase or project. It needs to be long enough for meaningful improvements to be made. You can take into account the effect, if any, on relationships with the customer, as this may be relevant to the timescale for improvement. For example, if the employee is causing damage to those relationships, a shorter timescale is likely to be reasonable. You will need to offer support or training to help the employee achieve the required standard during the timescale given. You will also need to review progress during that review period. You will have notified the employee that their performance will be monitored and discussed, and therefore you need to make sure that we are doing what we've said we would. So once we've been through these steps and the employee fails to improve sufficiently during the set review period, a formal meeting should be arranged. We write to the employee, and in that letter we will cover the usual things such as the details of the poor performance, the date and time of the meeting, a summary of any relevant information and evidence that you've gathered, a copy, if there is one, of your capability procedure, what the consequences of the meeting may be, and confirm that the employee, of course, has a right to be accompanied, which I will talk about in more detail in my next session. The purpose of that meeting will be to enable both the employer and employee to explain their cases to each other. It will give the employee in particular the opportunity to respond and give an explanation for their underperformance, explore and identify the cause of underperformance, determine what, if any, remedial action can be taken, obtain the employee's commitment to achieving the required standard, setting a reasonable time period to reach that standard, agree on a monitoring system, and explain what will happen next if the employee does not meet the standard. After the meeting, of course, we will write with an outcome of the hearing, just like in any other process, and that will explain whether a warning has been issued and how long it will be relevant for, what what disciplinary action, excuse me, may have been taken, what the targets and objectives are, i.e. the performance management plan that's been agreed upon, and what will happen next if there is no improvement. The letter will also set out the right of appeal and what the time frame for appeal will be. Let's have a look now at the decision to dismiss. Usually, unless there is gross negligence or the employee is within their probationary period and it is safe to do so, we won't dismiss in the first instance. There usually will be a written warning, a final written warning, and then dismissal. Before we give any warning to dismiss, any warning or dismissal, we will need to follow the same procedure that I've just been through at each stage. In other words, investigation, formal meeting, right to be accompanied, outcome objectives, and a further time frame for improvement. This means that you will potentially have to go through that procedure 3 times before you finally can dismiss an employee, which is why I said at the beginning it's often preferable to deal with matters before it gets to that time-consuming stage. Before we reach the decision to dismiss, we can consider offering alternative employment. There's no obligation on an employer to consider alternative employment or demotion before taking the decision to dismiss, excuse me, but it may be unreasonable in the circumstances if we do not. Whether it is reasonable will depend again on the size and resources of the employer. The bigger the employer, then the more likely it will be considered to be reasonable that they have looked at other opportunities that may be more suitable for the employee. Finally, to wrap up, I'll have a quick look at the issues that commonly arise during dealing with a performance management process. I've briefly touched on whether it's possible to dismiss instantly for a single act of incompetence. Although this will be rare, in the absence of any willful element, it will be highly unlikely that it will be so bad that instant dismissal for a single act of incompetence will be an appropriate response. However, where there is a particularly hazardous role, there may be an exception, and if an employee could cause themselves harm or others by their poor performance, then it may be reasonable to dismiss sooner rather than later. In most cases, however, employees are expected to investigate and offer support to employees before dismissal. What about employees who lapse after improvement? This is a frustrating situation and one that you may have found yourself in. You've issued a warning. The warning has been live for around 6 months. The employee has improved within that timescale, and then shortly after it lapses, the improvement tails off again. Where this happens, there's no choice but to start the process again, but you may wish to impose a longer warning period for the next warning. For example, instead of giving 6 months for a written warning, you may give 12 months. And you can explain at the time that the reason being that the improvement needs to be sustained and cannot deteriorate quickly after the warning lapse. What are the risks if we dismiss for poor performance? Well, there is, of course, breach of express and implied terms of contract. If we fail to follow a contractual, disciplinary or poor performance procedure, then this can give rise to a breach of contract claim. Usually the losses are limited to the time frame it would have taken for the employer to follow the procedure correctly. And we can easily minimise the risk of any such claim by ensuring that we follow our own procedures and, where possible, ensuring that those procedures are not contractual in nature to begin with. We may also breach the implied term of trust and confidence in the context of poor performance proceedings if there's been a failure to provide adequate support or training, or the matter is handled in such a way as to undermine trust and confidence. Again, we can minimise those risks by ensuring that the person dealing with the procedure knows what they're doing, that we act fairly and reasonably by carrying out a reasonable investigation, provide training and support, and identify any other issues and address them. We shouldn't be too heavy-handed in our approach. We should follow our own procedures, even if they're not contractual in nature, and we don't overreact with any disciplinary action taken. There is also a risk of an unfair dismissal claim, and this can either be express unfair dismissal or constructive. Common arguments for employees that their dismissal was unfair include allegations that poor performance was unfounded or unsubstantiated, they were not given prior warning, they were not given a reasonable timescale to improve, and the targets set for improvement were not realistic. Again, we can minimise the risk of a successful unfair dismissal claim by following the steps outlined today. And finally, there's a risk of discrimination and/or harassment claims from employees. Employees often look for excuses because they don't like being performance managed, and they can often cite discrimination and harassment as the cause. If we treat people differently, such as dismissing one employee who failed to meet performance targets while retraining another, this can add fuel to the fire of those arguments. So again, we can mitigate those risks by ensuring we treat everybody the same unless there is and ensure there is a clear and non-discriminatory reason from deviating from that. We ensure we follow an appropriate procedure and have a genuine non-discriminatory reason for addressing poor performance, then that should mitigate those risks. And that's the end of my section. I'll pass you over now to Michelle.
Thank you, Kate. Thank you. Right, so we're now going to spend a few minutes having a look at redundancy. This is another huge topic, so we're just going to look at some of the key areas today. What I'd like to have a look at is what is redundancy, what are the key risk areas and steps that you can take to minimise those risks. We're not looking at procedure again, and we're also not looking at the additional obligations that apply if you are looking to make 20 or more redundancies in a 90-day period where your collective consultation obligations would kick in. So firstly, if we're thinking about redundancies, we need to think how many employees are potentially affected. So work out the numbers. If it is 20 or more, then as I've mentioned, that will engage your collective consultation obligations, which are quite significant. So you would have to think about that in a great level of detail. And I would suggest that you take legal advice if you're dealing with collective consultations. But for our purposes today, let's assume we have under 20 employees. So we know numbers, now we have to think, is there actually a redundancy situation or not? Is it redundancy or is it something else? Why does it matter? Well, if we make somebody redundant, or you think you've made somebody redundant and the tribunal finds it wasn't actually a redundancy situation, that could make any dismissal unfair because the reason was something else other than redundancy. Most commonly, you see this in relation to a reorganisation where there are lots of changes, but actually the reason is not redundancy as a matter of law. It would fall into the some other substantial reason category relating to a change in terms and conditions, which Chris will look at shortly. You might still be okay if you followed a proper procedure and consulted, but it's always better to think about what your reason is at an early stage, not when you're in the employment tribunal. Also, just to mention that if the tribunal finds that there was a redundancy situation, they could still go on to find that your reason for dismissing that particular employee was not in fact redundancy. In particular, if only one person is made redundant, a tribunal will look at whether there is actually an ulterior motive or whether there's an agenda there. So it's important for us to establish, is there a redundancy situation and will the tribunal accept redundancy was the reason for dismissal? There are two broad definitions of redundancy. One, very broadly, redundancy applies where you need less employees to carry out work of a particular kind. And secondly, again, very broadly, where you close a business down entirely or you close the site at which employees are employed. If you think there's a redundancy situation, the next thing to check is whether you've got a redundancy policy in place and whether that policy, if you have one, is binding. If there is a policy in place and if it is binding, then it might tie your hands as to what you do during the redundancy consultation process, including whether you have to open up for volunteers for redundancy, the criteria that you will apply, whether you've got to pay enhanced redundancy payments, etc. You might be able to depart from a redundancy policy even if it's binding, if there are substantive business reasons for doing so. However, it will be harder for you to justify departing from your obligations regarding, for example, enhanced redundancy payments than it might be if you are changing selection criteria. Redundancy policies, in my view, are not the best idea because they can tie your hands in a situation where you need the most flexibility. So I would say if you don't have one, don't introduce one. So once you know where you are as to, is there a redundancy situation? Do we have a binding redundancy policy? The next thing you need to look at is whether there are any alternatives to redundancy. So for example, can you restrict recruitment? Can you reduce or stop overtime? Can you try to agree a reduction in hours or pay as an alternative to redundancy? What about volunteers? So I've mentioned this already. Do you have to invite volunteers for redundancy? Unless you're bound by a redundancy policy, no, you don't. People do have different views on this. It can be a good idea if you're willing to accept anyone who volunteers for redundancy, or you know who's going to volunteer and you're happy to accept them. But often asking for volunteers can backfire, because you might get volunteers that you actually don't want to lose, and or who will cost you a lot in terms of redundancy payments and notice pay as a result of their length of service and contractual obligations. You can turn down volunteers, provided your invitation of asking for volunteers is worded appropriately. But if you turn down volunteers in the department and then go on to select other employees for compulsory redundancy from that department, they can then argue that actually their dismissal was unfair because somebody else volunteered, you didn't make them redundant, and you compulsorily made that person redundant instead. In addition, asking for volunteers can delay the process, and in redundancy situations, delay can be dangerous. Sometimes it can't be avoided, for example, collective consultations, but if you can avoid delay, it's best to do so. The reason being is that the longer the process goes on, the more unsettled your workforce is, and also there is more scope for those who aren't at risk of redundancy but don't appreciate they're not at risk at that point to become unsettled and start looking for another job. Once you've decided that redundancies are necessary, the next step is to work out your pool from which you're going to identify those employees who will be placed formally at risk of redundancy. In relation to pooling, you should have a great deal of flexibility here. You might not need a pool at all if you have employees who are all in unique posts and their positions are not interchangeable or the same as other positions within the business. But if you have several employees carrying out the same or similar roles and you need to reduce the number of employees carrying out those roles, then a pool may well be required. You need to be able to demonstrate you've considered carefully what your pool should be, who should be in that pool. If everyone's doing the same job, that's quite straightforward. Those people would go in that pool ordinarily. But if employees have covered for each other in other departments and there's regular changeover, interchangeable skills, you might need a wider pool to include people in a different department who might not be affected if they are able to cover for employees in the department who are affected and they regularly do so. However, if you have rational grounds for excluding certain employees from a pool, a tribunal should ordinarily accept that. I've mentioned on the slide bumping as well, so you should also think about if an employee is selected as being at risk of redundancy, should they be given the opportunity to drop down into a more junior group of employees and a selection carried out there so that somebody who isn't technically at risk of redundancy may be made redundant, allowing the truly redundant employee to take their role. Now that's something called bumping, which always seems incredibly unfair to me, but there we are. It's not an obligation on you to carry out bumping, but you should be seen to consider it if the circumstances require. So we have our pool. We now need to think about selection criteria. So how are we going to select which employees are at risk of redundancy from within that pool? So we will need selection criteria. That should be as objective as possible, but the tribunal will accept that actually there's got to be some subjective criteria there. For example, the ability to communicate with stakeholders and the ability to time and priority manage. We have to be able to demonstrate that we've scored employees against the criteria, these more subjective criteria. So we have to think, how are we going to do that? What factors are we going to look at? What are we going to base this on? It's helpful to have two people carry out the scoring process independently as well, and then take an average of their scores for each employee, because again, that seeks to help introduce more objectivity and impartiality. Once you have selected the employees who are at risk of redundancy, you would need to obviously go through a consultation process with them. We're not going through procedures today, as I've said, but I will say be prepared. Get everything ready. Draft all your initial letters and your scripts for consultation meetings in advance. Outline the consultation timeframes. And think about as well, are you going to offer an enhanced payment in consideration for employees entering into settlement agreements as well? Think about that at the outset, because if you are going to offer that, we can inform employees that that is a possibility if their role is confirmed as redundant. We can let them know that at an early stage in the process, and that can then avoid appeals and obviously give certainty there would be no claims if employees sign settlement agreements. In terms of the length of the consultation, that will vary in each individual case. As a general rule, it should be for a minimum of a week or two once somebody's placed at risk of redundancy, but we shouldn't set down a rigid time frame, because we won't be in a position to bring consultations to a close until such time as we have discussed all potential alternatives to redundancy and answered any queries and questions and challenges that the employee might have. What about alternative employment? Well, we are obliged to look for suitable alternative vacancies and to ring fence those vacancies for those at risk of redundancy. And if we're part of a group of companies, that obligation applies to look for vacancies within the group, not just the employing entity. We should offer available vacancies to employees where those vacancies are within their skills and capabilities. You don't have to create new jobs, but if you've got jobs that you think on the face of it aren't suitable for that employee because it's a lower level of seniority or a lower level of pay, I would say offer them anyway. Offer any vacancies that might be suitable, and let the employee tell you that they're not interested in those vacancies. So think about vacancies that are on a temporary basis, lesser pay, lesser status, or obviously vacancies at other sites and other group companies. It's better to provide full details of vacancies to let the employee go away and think about whether they're interested in that role or not. Ordinarily, there is a statutory trial period of 4 weeks that applies for an employee who accepts an alternative role as an alternative to redundancy. And if they unreasonably refuse an offer of a suitable alternative vacancy, they may forfeit their right to a statutory redundancy payment, although it's not usually advisable to go down that road. There is an automatic right for certain employees to be offered suitable alternative vacancies before anyone else at risk of redundancy, and that applies to pregnant employees, employees on maternity leave, adoption leave, shared parental leave, during that period of leave, and also for a period after they return to work, which is called the protected period. And from the 6th of April this year, employees on neonatal care leave are also entitled to be offered suitable alternative vacancies before others, and that also applies as well for a protected period after they've returned to work. In terms of the protected period, for maternity leave, broadly speaking, the protected period is 18 months from the date of the birth. So if the employee takes a full year of maternity leave, they're effectively protected for a further 6 months after they return to work. Similar for adoption. So obviously in that period, they're entitled to be offered suitable alternative vacancies if they're at risk of redundancy ahead of anybody else. With shared parental leave, it's a bit more complicated. If the employee has also taken maternity or adoption leave, those provisions apply instead. However, if they just take shared parental leave, protection starts at the beginning of parental leave, and if they take 6 weeks or more of consecutive shared parental leave, then they get this 18 months from the date of the child's birth or placement of the protected period. If they don't take 6 weeks, so they take only 4 weeks perhaps, then they only get this enhanced protection during the period of leave. And with neonatal care leave, the protected period again is essentially 18 months from the date of birth or placement. Quite complicated. In terms of minimising risk, make sure you follow the right procedure. Plan the process in advance. Make sure you know exactly what you are planning to do, but obviously you do have to have some flexibility as things can change in a redundancy process. Don't be tempted to cut consultations short, because if there are live issues that have not been addressed and closed off and the employee is dismissed, that could well give rise to an unfair dismissal. Make sure consultation is meaningful. So in particular, if an employee who's been scored as part of a pool and they've been placed at risk of redundancy, if they challenge their scores, look at that again. Don't just say, we've carried out the scoring, that's your score. Let consultations be meaningful, and also have the right staff carrying out the consultation process as well, because it's important that the manager sitting having that discussion with the employee knows how to conduct the process and is approachable for the employee to feel that they can challenge their selection, challenge the redundancy process without fear of being ignored. Chris, do we have any questions in relation to redundancy?
Yeah, one just come in. I was going to answer it, but I'll give it to you since you're
Okay.
there. How does the redundancy process work with someone on long-term sickness absence? The redundancy is not related to their absence. The department they're in is facing a redundancy situation.
Okay, so if somebody's off long-term sick and there's a redundancy situation affecting their department, then you would pull them in the usual way. But when you're carrying out your scoring, you would have to ignore, if you were scoring in relation to attendance, you would discount any sickness absence relating to a medical condition if it might be a disability. But essentially they would be scored in the same way. However, if they were identified as being at risk of redundancy, you would have to ensure that you are making reasonable adjustments throughout that consultation process to take account of that disability and the fact they are absent from work. But obviously it does present additional risks.
One other that's
And
just
one
come
other just come in.
If someone is on shared parental leave, or I suppose any other family-friendly leave, and are off for 6 weeks for their protected time, is that 6 continuous weeks or 6 across the board?
Well, it depends on the type of leave. So if it was shared parental leave, they would only have the enhanced protection when they return if they've taken 6 consecutive weeks off. But for the other types of leave, those provisions apply. So they're protected during their maternity, etc. leave period, and for the protected period once they return. I will now hand over to Chris to come and sweep up with our last 2 reasons of illegality and some other substantial reason.
Thank you. Right, so as Michelle just said, I'm left to cover the last couple of permitted reasons for a fair dismissal, starting with statutory illegality. Statutory illegality stems from the idea of the employment contract as well a contract. And so in certain ways, specific other contract law provisions continue to apply even to the employment relationship. A contract which requires performance of an illegal act is not enforceable as a matter of established law. To use a really extreme example, a contract with a hitman. That cannot be enforced by means of specific performance. You can't require somebody to commit murder, funnily enough. And both parties would, of course, be engaged in conspiracy to murder, which is illegal. For the purposes of the Employment Rights Act, the test is whether the ongoing employment could result in the employer or the employee being in breach of some kind of duty or restriction that's in place by law. And the definition is on the slide taken directly from the relevant section. So a few examples around this: employed as a driver when they don't have a licence anymore, not being of age to hold a specific type of licence. So I'm sure if I'm wrong on this, somebody on the session will correct me, but I think you have to be 21 to hold a 7.5 tonne HGV licence. So that's a useful example. Somebody on the call will know that because it's part of your job. Regulatory requirements. It's a criminal offence to claim to be a solicitor if you're not one. So if one of us is removed from the role, loses our licence to practice, we can't be employed as one. I've mentioned no jab, no job. I'm not going to talk at length about this one, but it's one that I think the question of statutory illegality has come up unexpectedly during the middle of the pandemic. Those of you who were involved in this will know, just very briefly, there was a regulation at the time requiring anyone entering into a care home to have had the COVID vaccines. A large number of people were dismissed for refusing to have them, and one of the defences used by their care homes was statutory illegality. The law said we could not employ this individual any longer. We had to let them go. Those cases, despite us being 4 or 5 years on, are still being tested. They are still sat in the various appeal courts. There is also a line of thought that statutory illegality would bar an associated discrimination claim. The Supreme Court have said where there is no inextricable link, where there is an inextricable link, I should say this is not the case. So, dismissing someone for not having a driving licence doesn't defeat a completely unassociated race claim. Of course it doesn't. But in the no jab, no job cases, as an example, there are a lot of associated religious or belief claims that were brought at the same time. So there is an argument there that those religion or belief claims are also defeated by the statutory illegality point. As I say, those are still making their way through the appeal courts. Watch this space. Statutory illegality, like all dismissals, is still subject to a reasonableness test. Did promise you'd be bored of that word. And so consideration should also be given to appropriate alternative employment if possible. So the driver who loses their licence, for example, you should be considering whether there's an alternative role they could be fulfilling that doesn't require them to drive a vehicle. The final one that is set in the Employment Rights Act is some other substantial reason. There is arguably a bit of an overlap here between illegality and SOSR in that most of the illegality points are also likely to give rise to non-performance of the job. But SOSR is very much a mop-up provision designed to allow for any situation which doesn't comfortably fall into one of the other 4 categories. So the first test here, and again, the definition's on the slide there for you. What is substantial? In a wonderful turn of UK legal phrase, it means more than whimsical or capricious. Helpful, unhelpful, but a lovely phrase nonetheless. I think we can safely interpret that as meaning more than simply we don't want the person employed anymore. The reasonableness and fairness tests are still going to be applicable too here, funnily enough, which means considering alternatives. Examples of SOSR dismissals, therefore, might include a business reorganisation, including a proposed change of terms. In other words, as Michelle suggested earlier, fire and rehire situations are technically some other substantial reason as the justification for termination. More on fire and rehire to follow towards the end. That is about to get a lot more difficult, but fire and rehire, a change of terms that is not agreed by the employee, can give rise to an SOSR dismissal. You need to justify your business case for not being able to employ people on the previous terms. Protection of a business interest, such as reputation, confidentiality, or pressure from a third party to effect a dismissal, can all be SOSR dismissals. If you're relying on any one of those, there are specific tests applicable to SOSR dismissals. You have to demonstrate a current and real difficulty or pressure and/or an immediate risk if relying on the confidentiality argument. The dismissal must, funnily enough, still be reasonable in all the other circumstances. What the tribunal is looking to do in those kind of cases, and generally SOSR more broadly, is balance the commercial pressure, the commercial difficulty that the employer is facing with the injustice caused to the claimant by a dismissal that is basically not for one of the other reasons. So it is always a case of having a good business case for the dismissal and some kind of objective justification which you would feel comfortable arguing in front of a judge. Other options would include the employee being imprisoned. They can no longer perform the contract. They're not ready, willing and able, or on expiry of a fixed term contract in principle. Be careful with that one. The simple fact that a fixed term contract has expired does not necessarily amount to a fair dismissal. The employee needs to be aware of it. You would need to justify that there's no ongoing need for the role as well, potentially. Last one there, the classic breakdown in trust and confidence, that final line that we all add to the end of usually a conduct dismissal letter, just as an extra belts and braces approach. To all intents and purposes, it's the opposite of an employee's constructive dismissal claim. The employee has damaged the relationship so much that it can no longer continue. There's been a breakdown of trust and confidence. Do be careful relying on this one. It's not a get out of jail free card for avoiding processes or procedures where there is a conduct dismissal in the background. The tribunal will be interested in establishing the primary reason, so we don't just get to call it breakdown of trust and confidence, avoid all processes, when it should have been a conduct dismissal with appropriate procedures. Most of us, talking as respondent lawyers here, prefer to have SOSR as the backup. We much prefer to be able to go to the tribunal and say, look, our primary reason was conduct, but if all else fails, here's our other justification, rather than relying on it as the primary reason. That said, there are situations where it will be the one and only reason, but if there is something else that you can call it, please try to. That does make our lives a lot easier and hopefully will make yours a lot easier. I'm also going to touch briefly on automatic unfair dismissals and discriminatory dismissals, both of which have been hinted at during the course of this morning. First thing to note with an automatic unfair dismissal is that the majority do not carry any form of service requirements. Of course, at some point in the next 18 months or so, as I'll come back to shortly, that might be completely irrelevant anyway. But under current law, it's worth remembering that most of these do not have the 2-year service obligation. Unfair dismissals, automatic unfair dismissals, are designed to protect employees who engage in some kind of protected activity, broadly speaking. As you'll see from the short list, that is not an exhaustive list by any means. It's usually about exercising some form of statutory rights or doing something that is considered to be in the public interest, such as whistleblowing. Therefore, it's automatically unfair if the sole or primary motivation behind a dismissal is determined to be because of pregnancy, maternity, asserting associated statutory rights such as leave, someone taking some other form of statutory family-friendly leave, engaged in lawful trade union activities, whether as a member or a representative, blowing the whistle on wrongdoing, taking steps to address, avoid or mitigate a health and safety concern, asserting a statutory right to paid holiday, minimum wage, or dismissals where the primary reason is a TUPE transfer. All of those far too much for us to go into detail in any way in today's session. Just be mindful for the last of those, for TUPE dismissals, there is a service requirement. Remember, the test with these dismissals is whether the decision was sort of tainted by one of these things happening in the background. So an otherwise fair conduct dismissal can become an automatically unfair one if a motivation of the decision maker was the fact that the employee who has been dismissed had just blown the whistle about them. Dismissals can also be deemed to be discriminatory, of course, and in these situations there is no service requirement. If an employee's employment is terminated and the reason is a protected characteristic, this is direct discrimination. However, other procedures and processes which lead to dismissal, and this can include resignations, so an employee under 2 years who does not have a constructive dismissal claim ordinarily can still resign and say that their dismissal, their resignation was discriminatory in nature, does exist. That is a thing. Although often a form of direct discrimination or argued as harassment, dismissal claims are envisaged specifically under Section 39 of the Equality Act. This links the various stages of the employment relationship to discriminatory conduct, and what the provision basically says is that you shouldn't offer, recruit, have terms, or dismiss in circumstances that are discriminatory. There's a lot more I could have said on both of those, of course. Absolutely not time for it today. I think I'm now handing over to Kate to mop up on some of the common issues that we've been talking about over the course of this morning.
Thank you, Chris. Yeah, as Chris said, we're going to have a look now at the problem areas that are common to most of the reasons for dismissal that we have looked at today. First of all, let's have a look at a failure to attend meetings or a request for a postponement, something that I'm sure most of you are familiar with. So what if the employee just doesn't turn up for the meeting or asks for it to be adjourned? Let's have a look first of all at requests for adjournment. We will need to consider, if we get such a request, what the employee's reasons are for adjourning. If there are genuine reasons, then this should be taken account of and the meeting adjourned. Likewise, if their chosen companion isn't available on the date that we've set, what should we do? Well, the onus will be in that situation on the employee to suggest another date, and we should accept this as long as this is reasonable and not too long after the original date set. What about ill health? Employees often say, of course, they're too ill to attend, and often they will cite stress as the reason. If this goes on for a protracted period, tribunals will recognise that there does come a time when a decision will have to be made on the information available. In some cases, it may be fair to proceed to dismiss without a meeting, but those cases are very rare and not something that we recommend. Before you take the course of action, you should think about any ways in which you can deal with the matter without meeting with the employee if they consistently say that they're not able to attend. For example, where the employee says they're too ill, then we can offer to meet them at their home, or we can offer to deal with any meetings by telephone or video call, or we can even invite them to produce written representations, which can be from them or their representative. Ultimately, we do have the option of seeking medical advice on whether or not the employee is able to attend, either remotely or in person. You are not expected to indefinitely delay until the employee decides they are well enough. And indeed, in the cases of stress, it's not usually medical advice will usually confirm that it's not good for them to drag out the meeting. So what if the employee just doesn't turn up? After the first time, we can write to them and say that we are rearranging the meeting and you should rearrange it at least once. But in that letter, you make it clear that if they fail to attend without prior notice or good reason for the second time, the meeting will go ahead in their absence and a decision will be made based on the information available. Excuse me. Let's move on now to the right to be accompanied. We touched on this obviously throughout our presentations, but let's have in a bit more detail. Let's have a look at what that right entails. The right is for workers and employees to be accompanied by a trade union representative or a fellow worker at a disciplinary or grievance hearing. As I said, the employee can be accompanied by one of the following: a colleague from the same organisation, a trade union representative, or an official employed by a trade union. Employers are not legally required to allow any other individual, such as a family member or legal representative, unless explicitly stated in a company policy or agreed upon in specific circumstances. And there will be circumstances where it will be reasonable to agree to that. In the meeting, what will the role be of the companion? Well, it's limited but important. They can provide moral support and reassurance. They can take notes for the employee. They can present the employee's case, including summarising points or explaining their position. They can confer privately with the employee, but the companion may not answer questions on behalf of the employee or disrupt the meeting. The employer's obligations in relation to the right to be accompanied are as follows. They must permit the chosen companion to attend the hearing. They must schedule hearings at a reasonable time that accommodates both the employee and their companion. Avoid treating employees unfairly for exercising their right to be accompanied. And not refuse a reasonable request for accompaniment. Failure to comply with these obligations may lead to legal repercussions, including a claim at the employment tribunal. If the employer unreasonably refuses to allow an employee to be accompanied, an employee may bring a claim in the tribunal, as I said. If successful, the tribunal may award compensation of up to 2 weeks' pay. Furthermore, failure to allow accompaniment could be seen part of an unfair dismissal claim and as part of the reasonableness. What about lawyers? Can they come to a disciplinary hearing? There is no general right to bring a lawyer to a disciplinary or grievance hearing. However, there may be circumstances in which it is appropriate. And some employees, for example, NHS hospital doctors, may have a right under their contracts of employment to be accompanied to a hearing. If an employee has a disability, it may be a reasonable adjustment to allow them to be accompanied by someone other than a colleague or union representative, and in theory, this could include a lawyer. Excuse me. Another common issue that arises during a process is where an employee raises a grievance during a formal procedure. This will usually arise during disciplinary proceedings or capability proceedings. So what do we do if that happens? Do we continue with the process, or do we postpone the disciplinary, redundancy or capability procedure while we're dealing with the grievance? As with everything, it depends on the facts of the circumstances, and a view has to be taken. We can take a view by firstly assessing the nature of the grievance, determining whether the grievance is related to the disciplinary process or if it's completely separate, for example, a workplace dispute. Next, we can decide whether to pause the disciplinary process if the grievance is about the disciplinary process itself. Where this happens, it may be appropriate to pause the process whilst the grievance is investigated. If the grievance is entirely unrelated to the current proceedings, the employer may wish to handle both processes simultaneously, but ensure that neither process unfairly influences the other. If an employee raises a grievance that they're being bullied by their line manager or that their manager is biased, then the line manager is conducting the hearing, then there are 2 options available. Deal with the grievance first and suspend the disciplinary hearing, or appoint another manager to deal with the disciplinary hearing, then deal with the grievance against the first manager separately. Finally, let's have a look at reasonable adjustments. Again, this has been touched on during the various presentations today and will always be a common issue in any procedure where the employee involved has a disability. Possible adjustments you may need to consider will include providing information in accessible formats, having additional breaks during meetings to assist the employee overcome fatigue or to take account of stress, giving or arranging for additional training or mentoring if the employee is not performing as a result of the disability. You will usually be expected to go further in terms of training than you might for an employee without that disability. Modifying any procedures by allowing an employee with a learning disability or who is suffering from stress to take a friend to act as a representative or a family member, of course, and allowing employees more time to prepare for any formal hearing if, for example, they have a learning disability or are off with stress. Failure to make any or all reasonable adjustments necessary can, of course, risk a claim for disability discrimination. And that is it for my bit. Are there any questions?
Can we decide who is a reasonable companion? So would a husband, partner, mother, father be appropriate?
As I said, there's no legal obligation for an employer to allow anyone other than a colleague or a TU rep to attend, but there may be circumstances where it is appropriate to do so. If they're, where the employee is off with stress, for example, it may be appropriate to have their partner attend with them. Where there is a disability, or in particular a learning disability, it may be appropriate. Generally speaking, in the ordinary way of things, it's not desirable always to have a family member there, particularly a husband or a wife or a parent, because they can often be fairly adversarial on behalf of the individual. But it will be a question of fact in each case. I think that's fair to say. Anything to add, anybody? No, shaking heads. You can't see that, but they're shaking their heads. I'll hand over to Chris for our final section today.
Thanks, Kate. Oh, you got excited for me. I'm already on my slide. Thank you. So, very much not a session on the proposed employment rights bill and where it is, but we couldn't do a presentation on unfair dismissal without discussing the elephant in the room and the proposed changes. Throughout the session, and there's two in particular that I want to focus on just very briefly. Changes to unfair dismissal rights, excuse me, and what will be in effect a proposed abolition of fire and rehire. A general update on the bill first. The latest 300-odd page version of it has made its way through the final reading of the House of Commons earlier this month. It is with the House of Lords for review. There's usually a bit of back and forth between them over technical points, but if all goes to plan, we may see this become the Employment Rights Act 2025 in the summer with potential royal assent. Massive health warning at this point, despite the various panic emails you've probably had from all sorts of other content producers, for lack of a better phrase. This doesn't mean that any of the provisions will immediately become law. The power will be reserved for the government to enact the various provisions as and when it deems fit. I suspect a slow rollout of the key provisions will follow. We may well return to the old April-October routine updates. The big one first then, and I suspect and hope the one will probably take longest to actually come into place, unfair dismissal rights from day one. The specific provision in the current version of the bill is Part 1, Section 23, which revokes Section 108 of the Employment Rights Act. That is the one that defines qualifying period, which has meant various things since 1996 and currently means 2 years. On that basis alone, therefore, it would appear that any form of dismissal from day one could require process, procedure, fairness, reasonableness tests, as we've been discussing throughout today, in order to establish a fair reason and also to avoid an argument around procedure. This is, of course, not only a potential nuisance, but an understandable cause of panic for anybody with employees. Section 3 of the bill, though, expands on this and adds a new section, excitingly, Section 98ZZA. This introduces an, quote, initial period of employment, which will in effect be a form of statutory probation. On present drafting, this is a 6-month period with the ability to extend to 9 months, but that of course is entirely subject to what the House of Lords come up with and what the government may introduce by way of regulation as and when day one rights do come in. The change to introduce the initial period of employment gives the government the power to change the application of Section 98 to apply differently during that period. This strongly suggests that there will be scope for a reduced, protracted process in particularly conduct, capability and redundancy situations during that initial period, therefore with a reduced risk. It's also worth remembering the value of tribunal claims here. Someone dismissed with 6 months service is going to have a relatively low value claim. Unless there's drastic changes to how that is calculated, there doesn't seem to be too much from a commercial point of view here to be concerned about either. So practically speaking, this is obviously important to be aware of, though you will need to start thinking about your processes and procedures now and how you intend to implement them in the future. But this isn't something that's changing tomorrow. That said, don't leave it too long. We all kind of took our time with the GDPR changes when they all came in. We don't want repeats of that and last minute panic. This is something that is likely to crop up in the next 18 months. Do start thinking about it nice and early. On the subject of fire and rehire, we've discussed this as an example of a possible some other substantial reason dismissal. That is, as I said earlier, likely to become much more difficult very soon. This is one that I think if we get royal assent this year will probably be implemented very quickly. Labour's original proposal was to abolish fire and rehire entirely. The bill doesn't go that far. What it does is introduce a new version of automatic unfair dismissal. In effect, it will become a defendable version of automatic unfair dismissal if a dismissal is based on a proposed change of terms and the employee's refusal to accept those changes is the reason for termination. The limited defence to this would be basically absolute commercial necessity. The exact current wording is that either the change has to be implemented to eliminate, prevent, significantly reduce or mitigate the effect of any financial difficulties which were likely to cause the business to stop trading, to all intents and purposes, or, in all the circumstances, the employer could not reasonably have avoided the need to make the variation. Both of those, I suspect, are going to be very high thresholds and will come alongside some updated penalties as well. If passed in its current format, protective awards, that's the monetary penalty issued by the tribunals for things like a failure to consult, will double from a maximum 90 days gross pay to 180. In response to those announcements, the warning is basically, coupled with the fact you've got a potential 25% uplift for failure to comply with the code of practice if one is produced on dismissal and re-engagement, employer penalties could actually end up being quite high on that specific point. If you're considering contractual changes where there's any risk that they might not come with the consent of the employee, start thinking about that now. The consultation exercise needs to be ongoing while it's still relatively easy, he says, compared to how it will be in the future. In terms of next steps, it will be important for employers to stay ahead of these proposed restrictions. We will update as often as we can, but only when there's changes we know are going to happen. Today's session deliberately wasn't on this because it is still all quite speculative. But please do be aware of the current case law as well regarding enforceability of things like flexibility clauses and your ability to change people's terms anyway. I am very conscious of time. I'm very conscious that this is not a session where we want to run on for hours. Very quick plug from me before I hand back to Michelle to finish. Sessions like this, my coffee break briefings every Wednesday, first Wednesday of the month. The next 3 are all going to be on the tribunal process, leading to Save the Date, our next in-person event, 18th of June, which will be a mock tribunal. I'm sure Michelle was just about to say that, but she asked me 3 days ago to say it. I remembered to do so, so I've done my job. I will hand over to Michelle to finish off.
Thank you very much, Chris. So just to say from me, thank you very much for coming along today. Really good to see that so many of you could make it. We will circulate the slides and the recording. If you do have any questions following up from the seminar, our contact details are there at the end of the slides. Do feel free to give us a call or drop us an email. Chris has mentioned dates for diary in relation to the mock Employment Tribunal on the 18th of June. In addition, we are going to be having a seminar on the 24th of September, which will be an update on the Employment Rights Bill, in the hope by then there will be more flesh on the bones, as it were. Details of both those events will follow. So it just remains to say again, thank you very much for attending today, and we hope to see you soon. Thank you.